Today, the court continued a long-standing doctrine of not involving itself in partisan gerrymandering cases. Not that surprising, really, at least to me. There are a lot of wrongs that the court is capable of righting. And again, nobody likes partisan gerrymandering. We think it's wrong. But there are certain kinds of areas where the court, even if they recognize a wrong, do not think that it's in their scope to remedy. The court was under immense pressure in these cases. They did take one case that was a Republican gerrymander, another case that was a Democratic gerrymander. What the court has asked is that there be a very clear, enforceable standard for what constitutes an unconstitutional partisan gerrymandering. And one of the things the court ruled today is that no such standard exists. They don't have a benchmark against which they can judge a districting as being constitutional or unconstitutional. One of the things to understand about districting is there's never going to be a perfect districting. No districting for legislative districts is going to satisfy everybody. The effects of the decision will, in some cases, embolden those that are trying to gerrymander districts for partisan purposes. I think now that the judicial remedy, the federal judicial remedy, is off the table, it's also going to motivate people at the state levels to go back and take a look at their districting processes. I think people are thinking themselves as winners and losers because they're thinking about congressional elections now. What does this mean for my congressional district in 2020, for example? I think if you take the long view about court intervention in districting, that's not as clear who's a winner and who's a loser. The court will change. And so what you have to think is, what does this mean in not 2020, but what does this mean in 2040 or 2050? And that's really hard to say.